We could start with the Zachary Whaley case.
Right, and I've got some people on Zoom. I don't know if you can see, but we've got a post, Miss Badgley, somebody named Kayla, somebody named Jay, Ariane, Miss Hauser, Joanna's iPhone, and then some on cell phone that I have to identify. Just so you know, there's people on Zoom.
Thank you.
All right. So where did you want to start with England?
No, if we could actually start with Zachary Whaley.
Okay.
AP and Matt Nagel is going to be handling.
All right.
Your Honor, this is actually going to be a waiver.
Okay. Mr. Zachary Whaley. You're from the Chartier Law Firm. What's your name?
Marissa Vinsky.
And Mr. Nagel, you're covering on this case.
Yes, Your Honor.
Is this Judge Wardcade or is this?
No, Your Honor. This case is probably before this court. It's a vertical case.
Okay, thank you. All right, so we're on the record in docket 25-00-55522. That is People of the State of Michigan versus Zachary Whaley. This is the time set for preliminary examination. Will the parties please introduce themselves for the record? Mr. Nagel.
Good morning, Your Honor. Matt Nagel for the people.
Ms. Vinsky.
Good morning, Your Honor. Marissa Vinsky on behalf of Zachary Whaley, who is standing to my right.
And sir, you are Zachary James Whaley, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Mr. Nagel, how are we proceeding?
Your Honor, it's my understanding that the defense is going to choose to waive their right to the preliminary. The people will also unconditionally waive their right to hold a preliminary exam. There is no offer to stay on the record at this time, but negotiations will continue once the circuit court receives this case.
All right. And is that a fair statement, Ms. Whaley? It's my understanding the defendant's going to waive his right to a preliminary examination today, and negotiations are to continue in circuit court.
That is correct.
All right. Thank you. May I inquire of your client of his waiver of the preliminary examination?
Yes, Your Honor.
Mr. Whaley, you understand you have a right to a preliminary examination today. A preliminary examination is a full cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Marissa Vinsky, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court, where negotiations between Ms. Vinsky and the people of the state of Michigan will continue. Is it your wish today to waive your right to a preliminary examination today?
Yes, Your Honor.
Mr. Nagel, do you also waive the people's right to a preliminary examination today?
I do, Your Honor.
All right, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made, and I'll provide the bind over documentation to my court officer for signature.
We're closer. Just closer.
Would you like us to check your boxes?
I don't think so.
Thank you.
But I'm in possession of the bind over documentation on 25-00-522. This has been signed by all the parties. Let me indicate on box 3, the examination was waived on today's date, which is April 24th, 2025. Is there anything else before I sign the bind over documentation to come from the people of the state of Michigan, Mr. Nagel?
No, Your Honor.
Ms. Vinsky, anything from the defendant?
No, Your Honor.
All right, Mr. Whaley, your time in district court is done. You're off to circuit court where your case is going to continue. You'll get your next date from your attorney, Ms. Vinsky. All right, sir?
Yes.
All right. I will sign the bind over documentation and thank you everybody for your appearance.
Thank you, Your Honor.
Thank you. Have a good day.
You too.
No, you're not. No, not at all.
Let me identify some of these people and then we'll call the next case. So on the Galaxy 23, would you please identify yourself?
My name is Terry Allen Smith.
Terry Allen Smith, and you're here for your 9 o'clock?
Yes, sir.
All right, you stand by, sir. You're in the right place. And then
All right.
on the Motorola Moto G 5G, would you identify yourself?
I'm Anthony Anglin.
Anthony Anglin. All right, and you're here for your 8:30 with Mr. Goodrich.
Yes, Your Honor.
Yeah, you're set for sentencing today. All right, stand by. I
Yes, sir.
think those are the two that we have that.
One of those might be mine in the exam, but I'm not certain.
Which one's that, Mr. Feigelson?
Devin Fraser might be the one in the max cell, yeah, possibly.
And so that's Mr. Is there a Devin Fraser?
Hey, right here.
All right, all right. You got it, Mr. Feigelson.
Yeah.
All right. So we'll have that. We'll have him renamed as Devin Fraser. And then Mrs. L, where are we proceeding today?
That is a great question. If we want to just go ahead and call the Fraser case. we could do
Sure.
that.
No,
Sure, Jim.
Miss Sigmund just joined. All right, so let's go on the record. Let's go. Fraser. That's offensive. So we said, all right, so we're on the record in docket 24-02956. That is People of the State of Michigan versus Devin Fraser. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Bell, Assistant Prosecutor for the People.
Mr. Feigelson.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson on behalf of Devin Fraser. He is in custody, Your Honor. He is present by way of video conferencing this morning.
Then, sir, once again, you are Devin Fraser, is that correct?
Yeah, and Devin Fraser.
All right, thank you. And Mr. Fraser, you can hear me all right?
Yes.
All right, thank you. This was set for control date. We were awaiting an evaluation report. Do we have so what is, how are we proceeding, Mrs. L? I have a report from October 31st, which is incompetent but likely to attain competence.
That's correct, Your Honor. We're still waiting for an updated report.
Okay.
I believe they're waiting for a bed to open up for that report to be taken.
Is that your understanding, Mr. Feigelson?
That's correct, Your Honor. I'm not sure how long that is. Sometimes, depending on how long that is, they also do another re-eval to determine if he's competent. At this point, we're just waiting for that process to begin. The question I'm wondering is, I know they have 18 months. I'm just trying to get an idea on that timeline where we are.
Yeah, this is the problem we're concerned about, getting the report here. And what we've done is set control dates to make sure that it's, that we keep track of the file. But it looks like this was initially set as a control date on March 13th, and then we set it for today's date. The question is, are we going to have a report beforehand? We don't even have we don't have an evaluation.
Right, and I
to complete
suspect
the
that
report.
we may be still waiting through the summer, potentially early fall. I'm not sure.
That's
About
my
a year wait. It's
Yeah.
about a year wait.
That's my fear, is that that's the problem we've had. Well, that's the problem we've had with the forensic valuation. So my take on it, and I'll listen to anybody's idea, is to set it for another control date and then to make sure that the evaluation, since we need at least an evaluation done to do a report, that we get it sometime in the next, so we contact, but we're waiting for a bed.
Yes. Judge, he did have a new matter in East Lansing maybe a month or two ago. So they may already have done a new eval from East Lansing. I don't know if that's.
I don't know. Do we have a packet on that, or do we?
I know he was sent because our office represented
Right.
him, but I don't know if we got a competency report back yet or not. It's not my case. I think Mr. Foreman's handling that.
Yeah, and of course, if we've started the competency, he can't make any decision on that case.
Right. That's
But
what
for
I'm saying.
Raymond,
Yeah, right.
Does he have 18 months from the day he's found incompetent?
He has 18 from the day he's found
Incompetent, right?
incompetent.
Okay,
And he was,
don't remember, Mr. Feigelson, did either you or I reach out to them at the last hearing date?
I'm not certain. I think Ms. Schroeder was here because I think Ms. Schroeder's been
Okay,
helping me with this.
I will
matter.
send an email to see everybody on them to see if we can get it up. See-
I think you did it the last year, 'cause I remember getting an email about it though, Wendy.
Okay, I'll send them another one, not that it.
This he's October of 2024.
That sounds right.
So
It
we're-
looks like we referred him for competency on October. And then he was found incompetent on October 2024.
Yeah.
Pretty soon thereafter. So let's contact we'll contact the center, see if we can get a speed, any type of acceleration on the process. And we'll set it for another control date, 60 days out, I would think.
Judge, I do know he has a matter in front of Judge Ward as well, and we're also waiting for, but that case maybe a few months before us. I don't know the status, if they sent
They
they may have sent just one update. I don't know if that got to that file or not.
let's check on because that could get him the bed that we need and the evaluation. I've just kind of had luck and kind of haven't had luck with these with getting somebody to see reported and then the evaluation and then the reporting has been inconsistent.
No, and their last contact, they have, their review hearing is set out to July.
All right.
And
Let-
apparently they don't put theirs on the record.
All right. So let's do 60 days out. So we'll do a control date.
Wendy, if I get an update from them in July, I'll make sure.
Let
we
us know. Yeah.
Okay, thank you.
So we'll have a 60-day control date and we're waiting a report, which comes with a bed
Right.
for competency. And we'll get a date of
June 27th at 8.
June 27th at 8:30 for review. And in the meantime, we'll reach out to this office will reach out and CC both Mr. Feigelson and Mrs. L on any correspondence we have, but we'll reach out and say, we need this, this has to be done, at least a bed and some evaluation, because then we're waiting for the report
Right.
after that. So, all right. So we've reset it for June 27th at 8:30. So Mr. Frazier, Mr. Feigelson will be out to see you. We've reset it for June 27th at 8:30. And we want to get you evaluated for competency. And that most likely means that that you're going to get a bed or a bed at a facility in order to get the evaluation process going. All right, sir?
Yes.
All right.
Judge, do you want me on Zoom on that hearing, next hearing in June?
That's fine. That's fine if you want. Yeah.
Unless he's here in person.
Yeah. I don't think right now we're unless you tell us we're not bringing anything from forensic, but if you tell us, then we'll bring him in. But you can equally meet with him on Zoom.
Yeah, I don't think I need him here unless.
Right. I don't think so. I don't think so either. All right. All right. So anything else for the record in 24-02956, we reset a control state for June 27th at 8:30. Mrs. L.
Not for the people.
Mr. Feigelson.
Nothing else on behalf of Mr. Frazier, say your.
All right. Thank you. You're all set. Thank you for your appearance today, Mr. Frazier. We'll see you on June 27th.
I'll be in touch soon, Devin.
Great. They're all good already.
No, of course.
All right, Ms. Badger, you can unmute. We'll call your case next.
Okay.
Thank you. All right, so we're on the record in docket 2501-073. That is people of the state of Michigan versus Bridget Badgley. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Conlon.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Bridget Badgley, who is appearing separately by video.
And ma'am, you are Bridget Badgley, is that correct?
Yes, Your Honor.
And you can hear me all right, Ms. Badgley?
Yes, can you hear me all right?
I can, thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that at this time we will be setting this for a preliminary examination.
All right, and is that a fair statement, Ms. Donnelly? We're going to leave on for preliminary examination.
Yes, at this time I have received an offer from the prosecutors. I will be speaking with Ms. Badgley after court today. I'll call you and we can talk about it, all right?
Okay.
All right, so we're leaving on for prelim on May 1st, 2025 at 8:30, May 1st being next Thursday. So they'll be left on for prelim for May 1st at 8:30. Anything else for the record in 2501-073, Ms. Azell?
Not for the people.
Ms. Donnelly.
Not for defense.
Ms. Badgley, you're all set. We'll see you next week at this time, okay, ma'am?
Okay, I will see you next Thursday.
All right, and that will be in person at 8:30, all right, ma'am?
Okay, sounds good.
Thank you.
Thank you.
And then we'll do Mr. Rios. And is Ms. Rios on the? I don't see.
She's got her video on, Ariana's.
Oh, Ariana. Oh. All right, so we're on the record in docket 2501-094. That is people of the state of Michigan versus Ariana Esperanza Rios. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Donlin.
An Assistant Public Defender Sarah Donnelly on behalf of the defendant Ariana Rios, who is appearing separately by video.
And ma'am, you are Ariana Rios, is that correct?
Yes,
And you can hear me all right, Ms. Rios?
yes,
All right, thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding today?
Your Honor, it's my understanding we're going to be leaving this set for a preliminary examination. An offer has been extended at this time to the defense. We have not heard whether that offer will be accepted, but it will be taken into consideration.
All right, and so we're leaving, is that a fair statement, Ms. Donlin?
That is accurate, Your Honor. Yes, an offer was made this morning from the prosecutor's office, so I will be in contact with Ms. Rios after court this afternoon, and we'll talk about it, and as we set it for the preliminary exam next week.
All right, so this is set, we've left it on for prelim at the probable cause conference for May 1st at 9 o'clock. That'll be next Thursday at 9 o'clock, and that'll be live in person, all right, Ms. Rios?
yes.
All right, anything else for the record in 2501-094, Mrs. Zell?
Not for the people.
Ms. Donnelly,
Not for defense.
you're all set. Thank you for your appearance today. We'll see you next week, Ms. Rios.
Alrighty.
So
Go on. Is it Mr. Smith? Right?
Yes,
All right. All right, Mr. Smith, we'll call your case. We're on the record in docket 25000986. That's people of the state of Michigan versus Terry Allen Smith. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Anderson.
good morning, Your Honor. Michael Anderson on behalf of Mr. Smith, who does appear via Zoom.
And sir, you are Terry Allen Smith, is that correct?
Yes, sir, I am.
And you can hear me all right, Mr. Smith?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, at this time, an offer has been extended to the defense for sobriety court. At this time, we would be asking for this to be adjourned about 60 days for the screening process to take place for sobriety court.
Is that a fair statement, Mr. Anderson?
It is, Your Honor. We do need to address Mr. Smith's waiver of his 21 days, which he is willing to do.
All right, so this is going to be a waiver of the 21-day rule and adjourn for screening for sobriety court.
Yes, Your Honor, and we can do less time if that's preferred by the court.
Is it our sobriety board?
It would be 55th sobriety court.
Okay.
So,
If it was ours, I had to do something.
yeah, I think they take the plea in 55th. I think Judge Owens takes the plea.
So I'd be asking for a longer period of time just because we
All
need
right.
to get the memorandum of understanding signed as well as the plea agreement signed.
Right.
Transferred, all that fun administrative.
So we'll adjourn and waive the 21-day rule. Let's do that first, and then let's figure out a time frame we can work with 55th. So Mr. Anderson, may I inquire of Mr. Smith of his waiver of the 21-day rule?
Yes, Mr.
Right.
Smith, can you hear me?
I'll go.
Okay.
Yeah.
Yeah.
So, Mr. Smith, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir, I do.
And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and identity of the person who committed that crime. Do you understand that, sir?
Yes, sir, I do.
It's my understanding it is your wish today to waive your right to a prelim within that 21-day rule. Have this be adjourned outside the 21-day period. You wouldn't be waiving your right to a prelim in general, just within the 21 days, so that we can get this screened for 55th for a specialty court. Is it my understanding it's going to be your wish today to waive your right to a prelim within the 21-day period?
Yes, Your Honor, I do.
All right. And Mrs. L, do people also waive their right to a prelim within 21 days?
We do, Your Honor.
All right, I find the waiver of the prelim to be knowing, voluntarily, and accurately made. And we'll set this outside of the 21-day period, of course, or we'll have a waiver of the 21-day rule. And then what's the time frame for 55th? It's going to be a little bit of time.
It will be, I believe it will be anywhere from 1 to 2 months.
So
Unfortunately.
I think that's a fair assessment, just based on, so 60 days, do you think?
I think 60 days should be fine.
Just to get the paperwork and everything rolling.
I set it for like another PCC though.
Yeah, let's set it for PCC in this court. And we'll set for PCC on
June 27th at 8:30.
June 27th at 8:30, and then we're awaiting screening from 55th, specialty court. All right, so we've set it for probable cause conference for June 27th at 8:30. Really is just a control date to keep this on the docket. So we hear from 55th and get that paperwork.
Thank you, Judge.
Anything else for the record in 25-00986, Mrs. L?
Not for the people.
Mr. Anderson.
No, Judge, thank you.
All right, Mr. Smith, you're all set. Keep in contact with your attorney, Mr. Anderson. We've set a PCC date for June 27th at 8:30. All right, sir?
Thank you, Your Honor.
You're all set. Thank you for your appearance today. We'll see you, Mr. Anderson.
You're welcome.
Thank you, Judge.
I believe we're ready on Mr. Kaplan's cases. So Buckner, I believe, would be the first one on the schedule.
All right, so Buckner and Mr. Kaplan, how are you?
Good. How are you?
Pretty good.
Sorry about all the mess yesterday, but I understand everything got done, so.
It did, and I didn't even know about it, so.
Oh, okay, all the better. I should shut my mouth.
It all worked out.
Yes.
All right, and Mr. Buckner is joining us via Zoom. So Mr. Buckner, you can unmute. Thank you. All right, so we're on the record in docket 25-01071. That is People of the State of Michigan versus Dante Buckner. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Your Jeffrey Kaplan, P74943, appearing on behalf of the defendant, who's appearing by Zoom.
And sir, you are Dante Buckner, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Buckner?
Yes, Your Honor. Are you able to hear me?
Perfect, thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be leaving this set for preliminary examination.
And that's a fair statement, Mr. Kaplan.
It is, Your Honor. Just for the record, there's not been any offer made in this case by either party.
So we will leave on, that'll be live, Mr. Buckner, on the sixth floor of City Hall of Lansing on May 1st at 8:30. So it's next Thursday at 8:30. We'll leave on for preliminary examination. All right, Mr. Buckner?
Yes, Your Honor.
All right. Anything else for the record in 2501071, Mrs. L?
Not for the people.
Mr. Kaplan?
Not for the defense, Your Honor.
All right, we'll see you, Mr. Buckner, here in this courtroom at 8:30 on May 1st. All right, sir?
Yes, sir, Your Honor. You have a good one.
You should be all set, sir. Thank you for your appearance.
Haynes.
King.
Ms. Roberts, we received an email from the probation officer that he's running away.
So
Oh, okay, thank
on
you.
Jackson?
Yeah, it's going to be a plea.
All right.
Your Honor, I believe it's going to be a no contest plea. I don't have a physical copy of the police report. If I emailed it to the court, would we be able to print that?
You can email it to Wendy and then
Sorry.
she'll print it out.
No problem. I just found them.
Assume you had a bigger copy, and you know what happens when people.
I'm waiting.
Did it
Sorry.
print it out in the middle?
All right.
Not a
Did you,
problem.
while we're waiting for the email, did you want to call any other case? You see,
Johnson?
we can,
You want to? We could do that. Hey,
Jesus
Jesus
Johnson.
Johnson, sorry.
Oh.
That was,
I don't think, is he here?
he is.
318-569-663.
Yeah, the rest of us.
All right, so we're on the record in docket 2500446. That's people, the state of Michigan versus Jesus Nathaniel Johnson, or Jesus Nathan Johnson. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Thank you, Your Honor. Jeffrey Kaplan, P74943, on behalf of the defendant who's standing to my right.
And sir, you are Nathaniel Jesus Johnson?
Jesus Nathaniel Johnson.
Jesus Nathaniel Johnson, thank you. All right, this is the time set for sentencing today. And Mr. Kaplan, you've had the opportunity to go through the pre-sentence report with your client.
I have, Your Honor.
Any additions, deletions, or corrections?
We just have a few cosmetic things. The very top left, his full name is Jesus Nathaniel Johnson.
So I've got it right on the file and on the pre-sentence, and then I corrected it on the judgment of sentence. Because we have Nathaniel Jesus Johnson as opposed to Jesus Nathaniel Johnson.
What I see on the pre-sentence report, it says Jesus Nathan. So I
Okay.
just want to make sure it's Nathaniel.
Jesus Nathaniel, I have Jesus Nathaniel on the pre-sentence report, but on the judgment of sentence, on the JOS, I have Nathaniel Jesus Johnson.
Okay. Under custody, right below his full name, obviously he's no longer in Shiawassee County Jail. So that should be corrected. Oh, I'm sorry, it says, yeah, it says 4/16/25 to the present.
Okay.
Although he did do the 9 days. Under the defendant's statement, it says that there is one attached. I do not see his statement attached. So I don't know if you received one. Can you make a written statement?
No, for this,
Yeah,
no, it's not.
so that should just be deleted.
All right, because I don't have a statement, but I don't know that he gave a statement.
No, he said he didn't.
All
but
right.
It does say here that one is attached.
All right.
Those are the only corrections we're asking, we're requesting.
All right. I will write in the D did not provide a statement, so one is not attached. And it is Jesus Nathaniel Johnson, right?
Right.
And Mrs. L, is there any restitution on this matter that you know, that you're aware of?
I do not believe there is, Your Honor.
All right. Allocution, Mr. Kaplan.
Your Honor, we're going to be requesting probation in this case, contrary to the recommendation. In reviewing the report, it doesn't appear that my client has problems completing probation successfully. What it addresses as the justification for jail term is his behavior when he's not on probation. But I think that that is not a justification for giving him jail. His behavior off probation is dealt with in the individual cases that he is sentenced for. If he's unable to complete probation, has a lot of probation violations, that would be a different story, but it doesn't appear that that's the case. I would imagine it seems that he does well when he's under supervision, which is what we want. The issues that he has when he's not under supervision are something that's related to his drug addiction. He does need treatment. He admits that he needs treatment, and he, as we were speaking earlier, would like inpatient treatment if possible. Part of the issue is that there is also this pending case in Shiawassee County now. So I don't know what's happening with that. He's not had his probable cause conference yet. That's going to happen apparently next Wednesday or Tuesday on the 30th. And I did explain to my client that, you know, depending on what happens there, if he gets probation here, it might be revoked based on what happens there. I did propose to him the option of just doing a straight jail sentence and getting credit for time served over there while he's serving here and not dealing with probation at all. But he would like to try probation. And again, he would like a treatment program so that he can try and continue to work to kick this habit. So with that, Your Honor, we'd ask for a term of probation. And that's it.
Thank you, Mr. Kaplan. Mr. Johnson, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I have suffered for years with mental issues, and I was in a very dark place. I'm not making any excuses for my drug use, but I do need treatment with my drug use. And as far as Shiawassee County is concerned, when I have my probable cause hearing, I am more than confident that. I'm sorry.
I don't want you speaking in detail about that.
Oh yeah.
About the actual facts.
Oh yeah. Oh yeah. I'm just saying I'm confident that that's going to be resolved without whatever. But yes, Your Honor, I suffer from mental issues, and I do have a drug addiction problem, but I do not have any problems when I'm under supervision. With probation, I have no problem.
Thank you. Mrs. L, is there anything you'd like to say to the court before the court passes sentence on behalf of the people?
No, Your Honor, we'll leave it to the court's discretion. Thank you.
All right. This is for a guilty plea for use of controlled substance. That would be the 1 year use. I've had the opportunity to see the CCH in the matter and to see the pre-sentence report that was put together by Jody Bayless. Mr. Johnson, you're not a kid. I'm not going to treat you like a kid, okay?
Of course.
Yeah, so and this isn't your first go around in the system, obviously.
No,
All right.
sir. No,
I've
sir.
got a CCH that dates back to at least conviction wise to 2000 for assault of crimes. At least one misdemeanor assault of crime, 2000. I've got a second in 2005, an assault of crime. I've got, and then use at a 2012. This is really, the misdemeanor is the present here concerning the time incarcerated.
Of course.
Not the amount of time. I can't give you over a year. I don't think, I do think that there's a long history of substance abuse here, okay? And a long history of, from some level of you have some priors on domestic violence, all right? At least out of 2000, 2005, you've got 2 priors.
Oh, yes,
right?
sir. But yeah, like I said, that's, yes, sir.
So, I mean, so I'm going to make my, and you've also got pending cases in Shiawassee County that we talked about. So I do not find you a candidate for probation at this time, all right?
Okay.
I just think you've been, I don't know if that's helpful to you. You can start getting your time on the Shiawassee case. If you're spending time, you'll get day for day credit. Is that that's what I'm thinking right now. But the recommendation is for spend 90 days in jail, credits given for 3 days previously served. I'll adopt the recommendation. So you can go with Megan, my court officer. That'll be an additional 87 days in jail for time previously served. Any fines and costs, I'll waive any fines and costs in this matter. Waive the crime victims' rights fee and waive the state minimum court cost fee. And so I'm not going to refer any, so you'll start clean. Okay, it'll be a clean slate for you in 87 days. Okay, but that's the judgment of the sentence today, and you can go with my court officer.
I have a staph infection.
Tell them that in the jail, and they'll see to it that you get any medical treatment that you need. All right, sir.
Yes, sir.
All right. So the sentence of the court is 87 days in Union County Jail. I'm going to waive in fines and costs and crime victims' rights and state minimum court cost fee. So that'll end up being a 0. Anything else for the record in 2500446, Mrs. L.
Not for the people.
Mr. Kaplan.
Not for the defense.
All right, thank you.
So there's no chance for rehab.
Wait, 1 second.
I'm sorry. Is that yours? Yes, sir. There's no chance for rehab. Could I write a couple numbers down on that?
I just waived the put out a new one.
It's up to you. You told me not to do it until you told me.
Yeah, let's not do it.
Or at least that was 3 weeks ago.
Yeah. Let's if I need to sign one, I will, but I think that one's kind of self-explanatory.
I think so. They ask a lot of questions and we'll know in the future we should go through it. How's that?
Perfect.
Oh, and here's your police report.
All right, let's go on. That is Mr. Jackson, right?
Correct. I think we've started with Mr. Jackson, yes.
All right. All right, let's go ahead and call Mr. Jackson's case. All right, so we're on the record in docket 25-01070. And this is People of the State of Michigan versus Christopher Jackson. Will the parties please introduce themselves to the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant who's standing to my right.
And sir, you are Christopher Jackson, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Mrs. L, how we proceed?
Your Honor, at this time, a plea offer has been extended to the defendant through his defense counsel. The plea offer would be to the count 2 of domestic violence under 750-812, which is a 93-day misdemeanor. Along with that, we would be agreeing to status under 7694A. And upon successful plea, we would be dismissing count 1 of the assault with intent to commit bodily harm.
So it's a plea to count 2. Count 1 is to be dismissed. There is a Killebrew agreement of 7694A status.
Correct, Your Honor.
And then upon successful sentencing and plea and sentence on count 2, count 1 is to be dismissed.
Correct.
All right, so I'll reiterate that for the record. This is a no contest plea, it's my understanding.
Yes, Your
All
Honor.
right, so it's a plea of no contest to domestic violence in count 2. Count 1 is to be dismissed. That is punishable by 93 days and or $500. There's a Killebrew agreement between the attorneys of status of 7694A status. Is that your understanding, Mr. Kaplan?
It is, Your Honor.
All right. And what is the reason for the no contest plea?
Intoxication, Your Honor. Lack of memory.
All right, and that's your understanding of Mr. Jackson. You'll be pleading no contest to the misdemeanor plea, which is ultimately punishable by 93 days and or $500. There's an agreement between the attorneys that you receive 769-4A status. If I was going to do anything, if I was going to not follow that agreement, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. All right. Mr. Kaplan may inquire of your client of his misdemeanor advice of rights.
Yes, Your Honor.
You understand that in this no contest plea, you have the following rights, and I'll walk you through those. All right, sir? So you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question the witnesses that are brought against you. You are represented today by Attorney Jeffrey Kaplan, who would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you'll give up the claim. The plea was a result of any promises other than what we've stated on the record concerning the no contest plea, that it was not your choice to plead no contest to the matter. Is that your understanding?
Yes.
You'd also be giving up the right to appeal anything from a no contest plea or for a jury trial. Since you won't be having a jury trial, you'll be pleading no contest instead. Do you understand that, sir?
Yes, sir.
Is it still your wish today to plead no contest to the domestic assault case?
Yes, Your
All
Honor.
right. I'm in possession of the police report, and this is what I'm using for the factual basis for the no contest plea concerning it's 255190327. Is that the correct? Is that the correct? I just have a printout. So is that the correct case number?
It is, Your Honor.
All right. And Mr. Kaplan, this is what I'm using as a factual basis.
Correct, Your Honor. Thank
Okay. So I find that this occurred on April 9th at 232 Frederick Avenue in the city of Lansing, Ingham County. And they were involved, and the defendant, Mr. Jackson, according to the police report that I'm using as factual basis, was involved in a dating relationship with the victim in the case, Amanda Burtz. Ms. Burtz indicated that she was offensively touched by the defendant. Either by the defendant's hands, offensively touched in a choking or striking way, and then it turned into somewhat of a mutual fray after that, it appears. And that this was not done in self-defense. Anything towards a factual basis for the offensive touching of another in a dating relationship with the defendant on April 9th on Frederick Avenue in the city of Lansing. Mrs. Zell.
No, Your Honor.
Anything towards a factual base for the no contest for the supporting factual basis, Mr. Kaplan?
No, Your Honor.
I find that the no contest plea based on the police report to support a factual basis for domestic assault. And then we'll refer to probation. So they'll make a decision based on the killabrew that's been offered. And Mr. Jackson, I know we took a no contest plea because of the memory, but please discuss with them anything you can remember about the event, okay?
Sure.
All right. And we'll set, so I'm going to refer you to probation, the 5th floor. It's all the way on the right. So you go down to the 5th floor, all the way to the right, and they'll either see you now or they'll set up an appointment to see you. I don't know what their schedule is concerning any interview, and then they'll do a report for me, and then we'll see what options available to us at sentencing. All right, sir?
Yes, Your Honor.
All right. All right. And we have a sentencing date of
June 27 at 8:30.
June 27 at 8:30. So we've set it for sentencing on June 27th at 8:30. And I'd go down and just find out when they set they set the time frame. Usually they don't see you right now on a Thursday afternoon, but they might. But they'll set up an appointment to see you. All right, sir? All right. Anything else for the record in 2501070? We've set it for sentencing on June 27th at 8:30. Mrs. L.
Not for the people. Thank you.
Mr. Kaplan.
Not for the defense, Your Honor.
All right, Mr. Jackson, you're all set. Thank you for your appearance today. And I'll return the no contest to the prosecutor.
Then, Your Honor, I believe Anthony England is on Zoom.
Yes.
Mr. Goodrich is ready. I think we could call that case.
All right, Mr. Anglin, we'll call your case.
Yes, Your Honor.
He was traveling in today, is that correct?
Yes, Your Honor. He was supposed to travel up from Kentucky. Unfortunately, he got in a car accident not long into the trip. So his vehicle is damaged. So he was appearing over Zoom. We would ask to proceed with the sentencing hearing with him over Zoom if possible.
And he'll be completing. Well, we'll talk about that. All right. So, Mr. Anglin, do you have video or do you only have audio at your location?
I have video and audio. I can see you all.
All right. So turn on your video and we'll see if that works.
Let's see.
It's usually a camera or a camera icon. I want to make sure that we're able to sentence you. So, Mr. Anglin, do you have video?
Yes, I have video, Your Honor.
All right, go ahead and turn that video on so I can see you.
Okay.
You may not know how to do that.
It's in a split. Let me see. Somehow it ended up, I have 8 screens showing, Your Honor.
Okay, Mr. England, you should be able to see all the other people, that's fine, but you need to have your own camera turned on.
Uh,
There's,
One
there,
second, I'm
there
trying-
should be a camera monitor with a line through it. And if you're able to press that, that'll take it off mute and you'll be on, we'll be able to see you.
okay. Let me try one more time.
Your Honor, if you have another short matter that you wanted to address, I could certainly try to give Mr.
Walk-
England a
walk
call
through?
and see if we
All
can
right. All right,
get it straightened out.
all
Okay,
right.
Mr. England, I'm gonna give you a call real quick.
So we're gonna make sure we can see you so we can proceed with the sentencing, Mr. England.
Oh, here
Okay,
he comes.
there it goes. Can you all see me?
Oh, there he is. All right.
I
Perfect.
had to find it.
All right, so we're on the record in docket 1805291. That is people of the state of Michigan versus Anthony Anglin. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Anglin, who is appearing over Zoom today.
And sir, you are Anthony Philippe Anglin, is that correct?
Correct, Your Honor.
Thank you. This is a time set for sentencing in the matter. Ms. Zell, is there any restitution on this matter? I don't see any.
I don't believe there is, Your
All
Honor.
right. Mr. Goodrich, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, we went over it this morning.
All right. Any additions, deletions, or corrections?
We do not have any changes.
All right. Mrs. Zell, do you have any objection to us proceeding with the sentencing via Zoom?
No, Your Honor.
All right. All right. For this 1805291 case, Mr. Goodrich, any allocution?
Yes, Your Honor. Your Honor, starting with the obvious, this is a case from that's 7 years old at this point. He's obviously he had some issues with substance abuse back at that time. He admitted to that when speaking with Ms. Bayless in this matter. He has not had issues since that time. That's why he has been able to, like I said, had this warrant out there for 6 years after the case originally got dismissed. He's been able to get a part-time job since he moved to Kentucky, where his family is residing, making $1,500 to $2,000 a month at People Plus. So he's always been very good about communicating with me when he had a matter. He was blowing up my phone yesterday as soon as the drive happened. So I was able to get a hold of him quickly and resolve the matter with your court. So we would just ask the court to follow the recommendations here. I think he can do a term of probation and with credit for the 11 days that he's already served in this matter.
All right, thank you. Mr. Anglin, is there anything you'd like to say to the court before the court passes sentence?
First thing is first, I would like to say welcome back, Your Honor. Secondly, I would like to thank the courts for granting me the opportunity to return home throughout this whole proceeding. And yeah, that's pretty much it. I would like to thank my lawyer as well. He's been wonderful. He's done an excellent job.
All right, thank you, Mr. Anglin. Ms. Zell, is there anything you'd like to say from the people's perspective concerning sentencing on this case?
No, Your Honor, we would leave it to the courts to.
All right. So so this is for a guilty plea taken on February 14, 2025 in regards to the controlled substance. It's a 1 year or I think it's a 1 year or $1,000.
I believe that's
Yeah.
correct.
So we will, it is ordered the defendant will spend 90 days in jail, credits given for 11 days previously served. The remaining time, which is 79 days, is to be suspended upon successful completion of probation. I'm going to set fines and costs: $200 fine, $200 cost, crime victims' rights fee of $75, state minimum court cost fee of $50, for a grand total of $525. Oh, I'm sorry. And then we have 30 days per month, $30 per month probation. So that would be $180. So the grand total would then be 525 plus 180, 705. That'll probably need to be pre-printed out since I messed that up pretty good. So you're set on probation via Zoom for 6 months at $30 per month. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or urinalysis as directed by your probation officer, no bars or nightclubs. Your probation officer, and I believe your probation officer would be Jody Bayless, has recommended that upon any positive test, defendant to enroll in complete outpatient substance abuse treatment or whatever substance abuse education they deem necessary upon any positive test. That's really to keep you clean and then address any problem if she sees any. All right, sir?
That's understandable, Your Honor.
All right. That's only matter. So I only have those at six months via Zoom pursuant to Ms. Bayless. I'll let you contact and keep in contact with Ms. Bayless concerning the appropriate Zoom schedule that they put on. And then really it's any substance abuse education upon positive tests, you should enroll any outpatient substance abuse treatment. So generally when people come and they violate their probation, it's because they test dirty. So just be aware of that. All right, Mr. England?
Yes, Your Honor.
All right. Anything else toward the judgment of sentence, Mrs. L?
Not for the people.
Mr. Goodrich?
No, Your Honor, thank you.
All right, you should be all set, Mr. England. You should keep in contact with your attorney, Ms. Bayless, with your probation agent, Ms. Bayless, concerning anything that they want to see on probation. But do you have any questions concerning the judgment of sentence?
Only one, Your Honor. With the total of my fines, is that something that I'm required to pay all at once, or will it be able to be installment plans?
You can pay that the fine. You can pay the total amount over the course of probation. So you'll have 6 months. All right.
Okay.
All right. Do you have any other questions, Mr. England?
No, Your Honor.
All right. Please keep in contact with Ms. Bayless, and you should be all set, sir.
I will, and thank you very much. Thank you, Mr.
Thank you.
Goodrich.
Okay, thank you, Your Honor.
Thanks, Dale. Thanks, Luke. Can I just call you Dale?
You
I
did.
don't know.
So what's your second name from the start?
Yeah.
Thanks, Judge.
I don't even know where I got Dale.
I guess he starts or Austin.
Well, notes, you just call whatever is in front of you, you know.
Right.
What? Bill, Fred, you know.
I answer to it all.
Yeah. All right, Ms. Terrell, we're ready to call your case. Is there a Cecilia Terrell on the Motorola? There you are. All right, you can unmute, ma'am.
Can you hear me?
I can. All right. All right. So we're going to call your case next. We're on the record in docket 24-02344. That is People of the State of Michigan versus Cecilia Marie Terrell. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Fivas.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson on behalf of Cecilia Terrell, who's present by way of video conferencing this morning.
Ma'am, you are Cecilia Marie Terrell, is that correct?
That's correct.
And you can hear me all right, Ms. Terrell?
Yep, I can hear you fine.
All right, thank you. This is the time set for forensic review in the matter. This is my understanding that we set this for a control date. We're waiting for on the latest report from the Department of Human Health and Services. We're waiting for a bed in order for inpatient status to attain competence. Is that a fair statement?
Correct, Your Honor.
Mrs. L, is that also a fair statement? That's a fair statement?
It is, Your Honor.
All right, so I would think in the waiting process, we probably have to set it out.
Okay.
Set it for review to see that a bed is able to be received or to be assigned, and then a report concerning restorability. That's what we're waiting for. So we'll set a date, a control date. And that'll be set for
June 27th at 8:30.
June 27th at 8:30. And we're awaiting competency for restorability.
That's correct, Your Honor.
All right, so Ms. Terrell, you will be contacted by your attorney and or the Department of Health and Human Services concerning that review and the evaluation and the report. All right, ma'am?
Okay.
All right. Anything else for the record in docket 24-02344? We've set the control date for June 27th at 8:30, Mrs. Zell.
Not for the People.
Mr. Feigelson.
No, you're not, Ms. Terrell, Your Honor.
All right, you're all set. Thank you, ma'am. Thank you for your appearance
Thank
today.
you.
Thank
Have a
you.
good day.
What time is that for set for tomorrow night?
Sure.
Make sure somebody's here.
Hadn't gotten that far yet.
That'll Where are we heading next?
If we could jump right into the Eugene Haynes case.
Right, so we're on the record in docket 25-00126. That is People of the State of Michigan versus Eugene Haynes. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Haynes.
And sir, you are Eugene O'Brien Haynes, is that correct?
Right.
Thank you. This is the time set for a sentencing in the matter. Mrs. L, is there any restitution on the matter? I don't see any.
I do not believe there is, Your Honor.
Ms. Robinson, have you had the opportunity to go through the pre-sentence report with your client?
I have,
Any additions, deletions, or corrections?
none at this time.
All right, allocution, Ms. Robinson.
Yes, Your Honor, we'd ask the court to follow the recommendation and sentence Mr. Haynes to a term of 6 months of probation. I believe that he'd be a good candidate for probation. He's currently working, has been abiding by the law while awaiting sentencing, has stable housing and family support. So I believe that he would be an adequate candidate for probation.
All right, thank you. Mr. Haynes, is there anything you'd like to say to the court before the court passes the sentence?
No, Your Honor.
All right, Mrs. L, is there anything you'd like to say to the court from the people's perspective?
No, Your Honor, we leave it to the court's discretion.
All right, I've had the opportunity to read the pre-sentence report and the that was done by Mr. Hanna. I'm largely in agreement with the judgment of sentence and the pre-sentence report. So this is for a guilty plea on February 6, 2025 for the attempt to R&O, which is a 1 year. I'm going to indicate that the defendant will spend 60 days in jail. Credits given for 3 days previously served. I'll suspend 57 days upon successful completion of probation, so there's no upfront jail. I'm going to set fines at $200 fine, $200 cost. Crime victim's right fee is $75, state minimum court cost fee of $50, and then $180. I'm going to place you on 6 months probation per the judgment of sentence. All right. So that was for the recommendation. So that I'll give you a grand total for that, and that can be paid over the course of probation. So that's 180 plus the 125. Plus the 400 fines and costs for a grand total of $705. Probation is for 6 months via Zoom, so that'll be through Mr. Hannah. And $30 a month for probation. The court rules that there's no assaultive or threatening behavior as a part of probation, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or urinalysis as directed and pay fees. Mr. Haynes, that is generally what people mess up on. Okay, that's why they're in front of me, because they drop dirty or their tests don't come back clean. Just so you're aware of that up front. All right. No bars or nightclubs. To continue with or to complete your mental health counseling as directed by the probation officer. Obtain and maintain employment and not purchase or possess firearms, ammunition, or weapons of any kind. All right, sir. Do you have any questions concerning the judgment of sentence, Ms. Robinson?
No, Your Honor.
Mr. Haynes, do you have any questions? No. All right. I'm going to sign the judgment of sentence accordingly. And then you should keep in contact with Mr. Hannah because he's going to be your probation officer. Pretty flexible guy, but you'll be able to work with him concerning the 6 months probation. All right, sir? Do you have any questions to me, Mr. Haynes?
I do have one question. So if I'm not able to pay the fines and costs by the end of probation,
then we'll decide. It's usually referred to referred for fines and referred to collections. And so that sets you up with the collections department. But make sure Mr. Hannah's aware of that, okay? Because there will be fees that come along with the random PBTs in your analysis. Those of course will take priority.
Okay.
All right, sir. All right. Any other questions, Mr. Haynes?
No.
All right. So you're all set. You might want to stop by and make sure you're on the same page as Mr. Hannah concerning probation reporting. Anything else for the record in 2500126, Mrs. L?
Not for the people.
Mr. Robinson, Ms. Robinson.
No, Your Honor. Thank you.
You're all set, ma'am. Thank you. Thank you, Mr. Haynes.
Thank you.
I believe Mr. Palmer's.
Is there a Jacob Cancino
Yeah.
on the
yes,
polygon?
Your Honor.
So, sir, you're
Yes, Your
Jacob
Honor.
Cancino in the Ingham County Post?
Yes, Your Honor. I'm in post one.
Are you, what's your name, sir?
My name's Thomas Dean.
In Ingham County Post, what's your name? You're dark right now.
Jacob Cancino.
That's Mr. Cancino.
Yeah.
All right. Let's go ahead and call that one.
All right.
Yeah. So. All right, Mr. Cancino, let's call your case. I have Mr. Palmer, your attorney is here. So we're on the record in 25-00593. That is People of the State of Michigan versus Jacob Cancino. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Cancino, who appears today via Polycom from the Ingham County Jail.
All right, and sir, you are Jacob Cancino, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Cancino?
Yes, Your Honor, I can hear you and I can see you.
All right. Thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be having this left set for the preliminary exam.
And is that a fair statement, Mr. Palmer?
It is, Your Honor.
So we'll leave on for preliminary examination at the probable cause conference for March. I have it for March. No, that's not right.
This was previously adjourned, Judge.
So when is this left on for? Do we have a prelim yet? All right. Because we set it for PCC on this date.
Your Honor, I was, if I can speak, Your Honor.
So it was adjourned, was left on for prelim, and then there was a request for adjournment by the defendant, and we set it for PCC for this date.
They thought that they might have a resolution, so we only set it for a PCC.
So let's set it for a new prelim date.
Maybe we do May 1st or Gabby, sorry.
What-
Is 5-1 enough time for your subpoena next week, or do you need longer?
I would probably need 2 weeks for it.
So May 8th or 9th?
Negative.
Oh,
You
because
guys
I'm
are at
not here.
conference and we've been asked not to stack to Judge DeLuca's
Yeah,
docket.
I'm not, yeah.
That was my concern, is I didn't want to have to go out to the 15th.
Can we do an afternoon on 5th or 6th?
That's a good question.
Yeah. But we'd have to make sure that Mrs. L's available and Mr. Palmer's available. Just because we don't want to set it out to the 3 weeks unless we have to.
I'd be available on either of those days. Really.
The afternoon of the 6th would work for me, Judge. I have a circuit court sentencing the afternoon of the 5th.
We do have quite a bit of civil that should go fast. Do you have any idea how many witnesses we're looking at?
I can make it probably 2.
2:30. On the 6th.
So we'll leave on for prelim on May 6th at 2:30. I do not believe Mr. Cancino has waived his 21-day rule at this point in time. So we'll set it for that date for good cause.
Understood.
So it's a good cause adjournment for May to March. I should restate that. So to May 6th, wow. May 6th at 2:30 for the preliminary examination. Anything else for the record on 25-00593? We've reset it for prelim on May 6th at 2:30. Mrs. L.
Not for the people.
Mr. Palmer.
No, Your Honor, thank you.
All right, Mr. Cancino, we've set it for May 6th at 2:30 for your preliminary examination. Anything else for the record? Mr. Cancino, you should be in contact with your attorney, Mr. Palmer, if you have any questions, and that's all for the record on that file.
Thank you, Judge.
Thank you, Mr. Palmer.
Remember the police were like, the police were like, well, yeah, we took the information, or the witnesses told you, I think that, but your office didn't have it, so it's hung up somewhere at LPD.
So has it? It was looks like it was referred to us. Literally the day after we had that. Okay, so I'll look
Just,
into that.
yeah,
and
look into
give
it, let
you
me
an
know.
update.
Yeah, appreciate it.
Absolutely.
All right, who did we bring up?
Stover.
Stover. So let's go ahead and go on Mr. Stover. So we're on the record in docket 25-00124. That is People of the State of Michigan versus Calvin Ray Stover. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Stover. Mr. Stover is present and standing to my right.
And sir, you are Calvin Ray Stover, is that correct? Thank you. This is the time set for a sentencing in the matter. Ms. Ezell, is there any restitution on this matter?
If I could have 1 second, Your Honor. Does not appear that there is restitution in this matter.
I have from the pre-sentence report that a letter was mailed to an impact statement was not submitted by the victim in the matter. And so there was, at the time of the pre-sentence report, there was no victim statement or any statement on restitution.
Correct, Your Honor, and we do not have any documentation or a request for restitution at this time.
Mr. Milks, have you had the opportunity to go through the pre-sentence report with Mr. Stover?
Yes, Your Honor, we had that opportunity to review it. Upon review, Your Honor, there's no corrections, deletions, or additions to be made.
Allocution, Mr. Milks.
Thank you, Your Honor. Your Honor, I'm asking that this court adopt the recommendations with some additional considerations to be taken into account, Your Honor. Mr. Stover faces numerous challenges, Your Honor, both internal and external at this point. He does struggle with mental health from time to time, but he's addressing that, Your Honor, trying to get proper medication, and I've been incredibly proud of him for taking advantage of his time in jail, Your Honor. I think it's important for this court to know that he has availed himself of multiple different programming options while he's being incarcerated at this time, including getting his license. And I'll let him explain that a little bit more, by getting a license through the LCC programs that are available there, as well as availing himself of treatment options, both in jail, Your Honor, and setting up treatment on the outside once he is released. He has set up enough through the jail's community programming, Your Honor, where he will be able to be transferred to, at some point, St. Lawrence, or at least avail himself of options from St. Lawrence, Your Honor, including getting proper medications. From there, Your Honor, he's also have the opportunity to go to RISE. At least that's his hope at this point, Your Honor. In addition to some of his mental health issues, he has struggled with addiction, which is also laid out here, Your Honor. And I think has led to, or been a huge contributor to, the actions in this case, Your Honor. And I believe that he would admit that as well. So he's struggling on these two modalities here, Your Honor. But I'm, again, very proud of him for what he has accomplished thus far, addressing not only his mental health, but also realizing that through RISE, he can achieve maintained sobriety from methamphetamine here, Your Honor. I would just like the court to also know, excuse me, that he has a hold from Eaton County. I believe it's going to be for probation violation because he has been on probation for child support, Your Honor. I'm confident he's going to be able to address that. If he's released from Ingham County Jail, he'll have to go to Eaton. I'm confident that he can address that before Judge Cunningham and do fairly well, especially if treatment is going to be an option for him on this probationary period, Your Honor. If there is anything further, though, I would leave it to my client, and thank you, sir.
Thank you, Mr. Milks. Mr. Stover, is there anything you'd like to say to the court before the court passes sentence?
You know, the jail, I really utilize the programming that there's there with Community Action Treatment Services, CATS, and CMH. Prior to being in jail, I've been using methamphetamine for 22 years, and I'm sober 100 days today, actually. And it's a big step in the right direction. I'm on psychological medication to where I can manage my day like I haven't ever been able to before. I got my driver's license through a program with the Secretary of State there at the jail. And I have one class left to get a certified analyst in logistics with my OSHA 30 through the LCC program the jail hosted. These are all programs that are huge barriers that I am using to overcome my, defeats.
Mrs. Ells, is there anything you'd like to say to the court before the court passes the sentence?
No, Your Honor, we leave this to the court's discretion.
All right. I'm in agreement with your lawyer that I do think a term of probation is accurate here. And you've made great strides concerning, as we know, the license is a big deal, okay? But not as big as being able to function under the guise of addiction, okay? And it's not easy. It's not easy for you. It's not easy for anybody, all right? It's just something you have to stay vigilant on every day. With that understanding, you have a past that makes me look at it and say, you've got to be really careful, okay? Because you've got assaultive behavior on your past. This is a domestic violence third case. And so part of this is aimed at rehabilitation for you, all right? To take advantage of district court so that I don't have to worry about you in 5 years. In the next 18 months, you're going to be on probation to me, all right? But in the next 5 years from now, you've got to make good decisions, all right? You really got to make good decisions. I also have to make sure that the community's safe, all right? And your history doesn't show that, but you've never attacked it the way you're attacking it now, okay? And so I think that goes to you. So I'm gonna adopt the recommendation, all right? Because I think it's twofold here. I think it is placing you on probation, which is good for you, but it's also taking advantage of whatever resources we have. And if RISE is working for you in regards to, you need to share that with your probation agent, right? I'm not going to make it a part of the order, but Mr. Sumter is going to look at what works. And if this is working for you, 100 days of being clean with methamphetamine is a huge stride. Okay, that's a huge stride. Now we've got to work on 101 days, 102 days, 103 days. You know, it just works that way. Okay, and then 10 years from now, it's the same vigilance. It doesn't change. Okay, it doesn't go away. But that's all right. Okay, it does right. It's hard, but it gets easier. But it's always hard. It's going to be always hard. And that's all right. Okay, that is the lot in life that's been dealt to us, and then we just choose what do we do in response to it. All right, I don't want to place it in any way that we're at fault for that, because we're not. Okay, it just happens, and then we respond to it. And you responded at this point in time. You responded well. Okay? You really have. So I'm going to say this is for domestic violence second. I'm going to order that you spend 365 days in jail, credits given for 24 days previously served. I'm going to suspend the remaining time. Okay. 341 days is suspended upon successful completion of probation. That is kind of, so there's no additional probation, no additional jail time. That's kind of the hammer. Okay. That's kind of what, that's what's hanging over your head. Okay. Fines and costs, I'm going to set fines at $200 fines, $200 costs. Crime victims' rights fee of $75. State minimum court cost fee of $50. Probation is for 18 months, so that's $30 per month. So that's at $480. This is an extended probation, but it's all for you to use our resources, all right? So I'm going to set that at, I'll give you a full, and that can be paid over the course of probation. Plus 480, so that's $1,005. Probation is set for 18 months via Zoom, so you can meet with Mr. Sumter via Zoom. No contact with the victim, Mitzi Mears, or be within 2,000 feet of where she works, lives, goes to school without consent of the court, unless I hear differently from her or the probation agent. There's a no contact order. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance. Submit to random PBTs and urinalysis as directed. That comes with a fee. That's generally the problem, okay? Generally, somebody drops dirty and they're in front of me, and you've got a huge jail sentence waiting for you, all right? But that's usually what it's violated on is dropping dirty. So just be aware of that. Okay, be aware. And violation of no contact order. I can't tell you how seriously the court takes this. If there's a violation of no contact order, if I have to believe you over Miss Mears, you're going to be in jail. All right. Just for the safety of the community, I respond in that way. All right. So if you see her in any way, or if she's, you call LPD and go the other way. Okay. If she's contacting you in any way, call LPD, indicate that you have no contact order, do whatever it takes to protect yourself. Okay, sir. All right. No assaultive or threatening behavior, no bars or nightclubs. You're to provide Mr. Sumter with any consistent mental health counseling and sign a release so he gets to see the mental health counseling. Obtain and maintain employment, not purchase or possess firearms, ammunition, or weapons of any kind. And then share with Mr. Sumter, he's requesting complete outpatient substance abuse treatment. If that's working, that outpatient is working, we're going to go with what's working, but I'm not going to make it a part of the order. I just want to make sure that whatever you do continues to be successful. 3 months is a huge stride, but 3 years is a bigger stride, and those are the goals we're setting for ourselves. And it doesn't matter where, as long as you're doing it. Okay, there's not a one size fits all. Okay, it is what fits, what works for you, and I think ultimately works for you is that at some point in time we understand that we have a destructive relationship with the situation, and we've got to improve that. We've got to improve that. Any questions of me concerning the judgment of sentence of Mr. Stover?
Yes, I do have a couple of things, Your Honor. The 24 days credit, why wouldn't I receive credit since I've been arrested in jail for?
We have 24 days. You'll receive all credit for time you've been in. We have 24 days that you have in.
I've been in since January 14th.
And that is correct, Your Honor. It was one thing that I wanted to bring up as well, just he has been in, I mean, I think the plea here was well over 24 days, or may have been about 24 days ago, but yeah, he's been in.
So this was done
17th at least, or I'm sorry, the 16th.
So the plea was on February 6th, right? Added count for domestic violence in the second degree on February 6th, and then the arraignment was on January 16th, is what I have.
Yes, Your Honor.
So, and were you incarcerated as of January 16th?
I was, and the 14th. I was arrested on the 14th.
Okay.
He has been in the entire time, Your Honor. And I've got 3 months, 1 week, 1 day, so 98 days, Your Honor.
All right. What do you think?
Judge, if I may, I can see on the roster that they send every morning that he was booked on the 16th of this, January 16th of this year.
Yeah, I've got that arraignment on January 16th, the arraignment.
That's his booking date as well.
Okay. And then I've at arraignment cash, the cash surety was set at $10,000.
Yes, sir.
So unless you made that, you should get credit for all the time from January 16th.
Once he pled to the misdemeanor on February 6th, it's an automatic 7-day PR. So I believe that's how probation calculates.
Yeah, so let's do, what's the date from January 16th?
January 16th to April 24th. I've got a date calculator. It's 98 days. Your
All
Honor.
right. So I'm going to give you credit for 98 days since you've been in. And that's 341 minus 98. So that's 243 days. Will be suspended upon successful completion of probation. Because I think you should have every date you should have every date you're in from 98 days, regardless of whether you pled to the misdemeanor or not. Okay. So credit is given for 98 days previously served. Will suspend 243 days upon successful completion of probation. So that should answer the first question. You said you had a second.
I'm facing a felony child support probation.
Let me take this real quick.
Is that
I
in Eaton
think
County?
it is, Your Honor. It's with Judge Cunningham. Regarding the fines and costs, like the court ordered 200 and 200 on each. We're asking if the court would consider waiving those fines and costs on top of the fact that he's going to have to pay for any sort of drug drops that come up and make sure he's continuing to pay his whatever his arrears are. We're asking if the court would consider waiving those fines and costs.
I can't waive those. Well, I won't waive those because it's a domestic second. Okay. There's a second. They're not high fines and costs, but I understand the request. I also understand that that this can be paid over 18 months time. Okay. So any fines and costs. So we'll stay the total $1,005. Of course, you can prioritize, tell Mr. Sumter, you know, as long as you communicate with Mr. Sumter, if you've got an ongoing child support case, priorities can be made, but it must be paid over the 18-month time. Okay. All right. Anything else?
There is a chance tomorrow when I see Judge Cunningham, she revokes my probation. It is my first couple violations, but I would hope maybe that would run concurrent if she gives, because she's going to give me the year if that's what she'll give me.
That's kind of interesting because if that, I think you should contact Mr. Milks immediately because he may want, if you want day for day credit, because if she incarcerates him,
right,
he should be collecting time on, I would think he'd want any time collected.
We would ask probably to revoke his bond.
Yeah, to release like $1, you know, some type of low cash or surety. So something is put on so you can get some type of credit because I'm putting you on probation right now.
Would there be any way you could get me back to this jail versus doing it in Eaton County?
I don't have that. I have control, but I don't have control over what Eden County wants. But I understand the request of Mr. Milks.
Thank you, Your Honor. I think that was gonna be if is there also a condition that he has to report to probation within a certain amount of time if released from Eaton, if and when released from Eaton County?
No, he's got to report to probation within 48 hours. But of his release from Eaton County,
okay,
he's just not at Eaton County yet.
Correct.
Yeah.
Yes.
But we know what's coming.
Okay.
You know, we know what's coming. What the worst thing that probably happened is you're released here and then you don't show up in Eaton County. They're just going to issue an arrest warrant for you, and then you're just going to end up in Eaton County with and possibly a violation on the warrant, which is you're just trying to avoid all that. So make sure Mr. Milks and Mr. Sumter know your status. Okay. All right.
And he will likely be transferred from this jail to
Eaton County if
expecting
for the felony it's paternity fee. It's child support.
It's child support probation.
Okay. All right.
Thank you very much, Your Honor. We appreciate it.
All right. Anything else, Mrs. L on 2500124?
Not for people.
We can print that out because it's kind of, I'm written all over it. All right, Mr. Stover, they probably will take you to Eden County. And if they do, we'll wait to get some type of motion for credit at the same time. Good luck to you, sir.
Thank you.
Okay.
Yeah, that's good.
Mr. Mouse, could you please assist me in handing that to me?
Reprinting.
I just say.
Oh, yeah, no, it's
You were all over that one. Good morning.
Oh, yeah. This one's. Which one does it go on? I can't remember.
Probation.
Okay. That's what I've been putting in it, but
If they get probation, it goes in the probation file. If they get something else, it goes in the criminal file.
one doesn't turn into the other. All right. How did you want to proceed, Miss Azell?
I'm not sure. We're ready on all of them.
All right. Want to go on, let's just go in order with, how about Mr. Johnson? He was on Zoom.
Yes, I believe he has 2 cases today. I believe both of them are going to be left set for a prelim.
Did you want to call his last? Is he gonna be here or?
If I thought he was remaining on Zoom.
Let's call Mr. Kaplan's case,
Sounds great.
Thomas Dean.
On Zoom.
All right, and sir, you are Thomas Dean, is that correct?
Yes, sir, Your Honor.
All right. All right, so we're on the record in docket 25-00915. That is people of the state of Michigan versus Thomas Edward Dean. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Honor Jeffrey Kaplan, P 74943, on behalf of the defendant who is appearing by Zoom.
And sir, you are Thomas Dean, is that correct?
Yes, sir, Your Honor.
And you can hear me all right, Mr. Dean?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, at this time, we're going to be leaving the set for preliminary exam.
Is that a fair statement, Mr. Kaplan?
It is, Your Honor. Just for the record, there has not been an offer made by the party.
Okay, so we've set for preliminary examination on May 1st at 9:30. All right, so Mr. Dean, we will see you on May 1st. That is in a week at 9:30 concerning your preliminary examination on this matter. Anything else for the record in docket 25-00915, Mrs. Zell?
Not for the people.
Mr. Kaplan?
Not for the defense, Your Honor.
All right, Mr. Dean, we'll see you in a week at 9:30. That'll be live in person. Thank you for your appearance today.
Yes, sir, thank you.
Do you want to do, well, we have Mr. Kaplan, did you want to go on Thomas?
Yeah, that's just going to be another set. Or a hold exam, date's already set.
All right, so we're on the record in docket 25-01113. That's people of the state of Michigan versus Terrence Thomas. Will the parties please introduce themselves for the record? Mrs. Zell.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Jeffrey Kaplan, P 74943, on behalf of the defendant who's standing to my right.
And sir, you are Terrence Thomas, is that correct? Thank you. This is the time set for a probable cause conference. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that at this time we'll be leaving it set for the preliminary exam.
And is that a fair statement, Mr. Kaplan?
It is, Your Honor, and for the record, the prosecutors offered to drop the halves if my client pleads as charged. My client at this point respectfully declines that offer.
All right. We will leave on for preliminary examination for a week from today, May 1st at 9:30. So Mr. Thomas, I'll be live in person on the 6th floor at 9:30 a week from today. Anything else for the record in 25-01113, Mrs. Zell?
Not for the people.
Mr. Kaplan.
Not for the defense, Your Honor.
All right, Mr. Thomas, we'll see you next week at 9:30. Thank you for your appearance.
Thank you.
We have Mr. Johnson and Ms. Don.
Yes.
And if Mr., I would think if Mr. Johnson doesn't rejoin us, we can just leave his on.
If you're okay with that,
Yeah.
Your Honor. We have been in contact via email and we have talked about both.
All right.
He
And
did
then,
leave me a message on Zoom. He said that they will be asking that these matters continue to exam. He is currently in a trial.
Okay.
So he's been on and off Zoom.
yeah, I thought he looked like he had a conflict. Did you want to go on Ms. Donnelly's case?
If she's available, I know she was going to be jumping in via Zoom because she was waiting for a PE and Buchanan. So if she's not currently running a PE. we
Let's
can
do,
absolutely-
let's do Ms. Hauser. So Ms. Hauser, you can unmute. Ms. Hauser, you can unmute. We'll call your case. All right, well, while Ms. Hauser's unmuting, or we can go on in the Ingham Jail Post 2 Visit 5. Could you identify yourself, sir?
Don Terry's hands.
Okay, that's Miss Donnelly's client.
We called Thomas Dean already.
Yes, that was Mr. Kaplan's. How about Miss Curry?
I haven't had her appear all morning. Even on Zoom.
Yeah, I don't think Miss Curry has shown up yet.
Okay.
I think and Miss Hauser is on mute. Miss Hauser, can you unmute? Autumn Hauser? All right, Mr. Mans, I think your attorney is in a prelim right now. So stand by and we're going to place you on the record once Miss Donnelly joins us. All right, sir?
Okay.
I'm admitting Miss Hauser and then another. And then Miss Hauser, you'll have to unmute.
I'm unmuted. Good morning, Your Honor.
Okay. All right. Let's go ahead and call that case. All right, so we're on the record in docket 2501072. That is People of the State of Michigan versus Autumn Hauser. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
And Mr. Johnson had joined us. He has a conflict. He's in another courtroom. He does have a conflict. He was a part of this. And ma'am, this is a probable cause conference. Ma'am, you are Autumn Hauser, is that correct?
That's correct.
All right. This is time set for a probable cause conference. In the absence of Mr. Johnson, who was here, Mrs. L, how we proceed?
Your Honor, it's my understanding we're going to be leaving this set for preliminary exam.
All right. So we're leaving this on for preliminary examination. It'll be left on for May 1st at 8:30. So Ms. Hauser, that'll be live on the 6th floor of City Hall of Lansing, May 1st at 8:30. You should be live for that preliminary examination. All right, ma'am?
Yes, Your Honor. I do have a question. Was I supposed to be in correspondence with my public defender before this?
Is Mr. Johnson a conflict counsel or is he? Okay. Yeah, so you should be in correspondence with Mr. Johnson. You have a week till the preliminary examination date on May 1st, but you should attempt to contact Mr. Johnson if you haven't already.
Okay. All right. Thank you.
And he indicated he's been in trial and that it was suspected that this was going to be left on for prelim on May 1st at 8:30.
Okay. Thank you.
All right. Anything else for the record in 2501072, Mrs. L?
Not for the people.
All right, Ms. Hauser, we'll see you live in person at 8:30 on the 6th floor of City Hall of Lansing. Thank you for your appearance today.
Thank you. Have a great day.
You too. All right, so we're on the record in docket 2500838. That's People of the State of Michigan versus Anna Curie. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
All right, this is the time set for a probable cause conference. Mr. Johnson was here. He wanted us to leave it on. I do not see Anna Curie in the courtroom today. So I'll leave it at your discretion, Mrs. L. We can just leave it on for PCC and then see what happens next week, or?
I think that would be the best
All
option,
right.
Your Honor, to
All
give
right.
Mr. Johnson an opportunity to get in contact with his client.
All right, so we'll set for preliminary examination. It was already set for May 1st at 9 a.m. So we'll leave on for preliminary examination, waive the appearance of Ms. Curry and Mr. Johnson, who was here via Zoom. And we'll set it for May 1st at 9 a.m. Anything else for the record in 25-00838, Mrs. L?
Not for the people.
All right. We'll see everybody here on May 1st at 9 a.m.
Did you not hear them say that?
So, Mr. Mann, we're gonna look for your lawyer, and then once she joins us, we're gonna call your case. All right, sir?
Yes, sir.
All right, so we're on the record in docket 25-01140. That is People of the State of Michigan versus Dontarius Mans. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the People.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Mr. Mans, who is appearing separately by video from the Ingham County Jail.
And sir, you are Dontarius Mans, is that correct?
Yes, sir.
And you can hear me all right, Mr. Mans?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Zell, how are we proceeding?
Your Honor, it's my understanding that the public defenders will be seeking conflict counsel on this case. With that being said, the people are fine either leaving it set for the preliminary exam to address the timeline at that time, or if we would like to address it today, that's fine as well.
All right, Ms. Donnelly, how would you like to proceed today? It takes some time to get conflict counsel, I know that.
It does, and more than likely, you're gonna have to find good cause to adjourn the preliminary exam, but I do prefer that we, at least address it next week.
Okay.
When we have to.
All right, all right.
But, well, yeah, let's just do that.
You want to leave on for next week and then we
Yes.
can address the conflict. You can get that paperwork started. And so, Mr. Mans, we're going to leave this on for probable cause for preliminary examination. We're going to leave on for May 1st. For May 1st at 9:30. And we'll address the preliminary examination on May 1st at 9:30. That'll be live in person on the 6th floor of City Hall of Lansing. Also at that time, there may be the necessity, the Public Defender Office has indicated that they may be seeking conflict counsel. If that is the case, and we'll know in a week, we'll address those issues at that time. All right, sir?
Yes, sir.
All right. So we've left on for May 1st at 9:30, Ms. Donnelly.
Only, Your Honor, I wanted to address bond.
Okay.
Briefly.
You may address bond at this time if you'd like.
Thank you, Your Honor. A question for the court, though, because I wasn't too sure. Is there a tether ordered in this case?
There is a tether ordered at arraignment. Bond was set at, I have got 10,000, 10%.
My understanding it was 10% of 10,000 as well. I just didn't know if there was a tether ordered. So
And there's a
you're saying-
GPS with house arrest ordered,
With house arrest. Okay.
according to the notes from Judge Simmons.
All right, Your Honor. Then, simply put, I just, Mr. Mans has been, he has the bond. He can't post it right now. does live with his mother. He is from Lansing, so I'm sure that with the court's conditions, he can remain in house arrest with the tether, following conditions if the court would consider a personal recognizance bond. Thank you.
Thank you, Mrs. L.
Your Honor, I do have some concerns as a dangerous weapon was involved in this case. It is not an assaultive case, to be clear. At this time, we don't see a need for a change in the bond, but we would leave it to the court's discretion.
Right, I'm gonna leave bond as is. I'll talk to Judge Simmons about why she set bond, but it set at 10,000, 10% with a house arrest for the CCW. The defendant is unemployed at this time, and a real road address was given, but I'll address that. We can address this at the preliminary examination. So the reduction in bond is denied at this time, which will give the court at least a week to look into it. Anything else for the record in docket 25-01140, Mrs. L?
Not for the people.
Ms. Donnelly.
Not for defense. Thank you.
All right. So I'll see you next week at this time. It'll be May 1st at 9:30. Thank you for your appearance today, Mr. Mance. And Mr. Meineke, you here on TNT Financial?
Yes, I am, Your Honor.
All right, thank you. All right. So we're on the record in 21-02347. That is TNT Financial versus Camille. Is it Camille Robinson? Baumel Robinson. All right, will the parties please introduce themselves to the record? Mr. Meineke.
Good afternoon, Your Honor. James Meineke appearing on behalf of the plaintiff TNT Financial.
All right. And sir, you are Kwame Robinson, is that correct?
Kwame Robinson.
Kwame Robinson. All right. This is the time set for, this was an objection. The parties previously met last year and they worked out an oral motion to set aside installments. It was July 9th of 2024 and August 20th of 2024. We're here on August 24th of 2025. And Mr. Robinson, you filed a motion to reduce the garnishment payments. It was at 60 and you're requesting 40. Is that correct?
Yes.
Okay. Have you had the opportunity to speak with Mr. Meineke? This is an objection to that order. Mr. Meineke, did you want a chance to speak with Mr. Robinson, or did you want to just go forward with your objection?
Well, Your Honor, I think that I talked with my client and they would agree to the $40 a week. Mr. Robinson also indicated he would like to have it deducted from his pay. I'd have to prepare an order that says that
All right.
it's separate from the, but we have no problem with doing that.
All right. So, Mr. Robinson, they're in agreement if you're willing to take a garnishment of $40 a week for the payroll, as you indicated in your motion. I'll entertain an order that I'd sign once Mr. Meineke advances it. Is that a fair statement? Is that essentially was your objection to the entry of order? It looked like a reduction of $40 a week per payroll request, and that should get you caught up, or that should start you on the process. Would that be a fair statement?
Yes.
All right. So I'm going to indicate that so you'll follow that up with an order, Mr. Meineke?
I will, Judge. I just wanted to confirm with Mr. Robinson that we have his correct email address.
Okay.
So it has the number 505 in it. Is that correct still, sir?
Do you have the number 505 in your email address?
Yes.
Yeah, then
Okay,
I'll
so-
submit the order to the court and favor Mr. Robinson with a copy.
All right. And so that's the same email address so if you could indicate that for the record, we're not on any streaming and there's nobody else in the courtroom. So
okay.
What's a good contact information? So they'll send you a copy of the order.
Through the email?
Yes.
My first and last name,
So,
followed by 505
okay.
at gmail.com.
Is that what you have, Mr. Meineke?
That's what I have, Judge.
All right. All right. So I will indicate the order to follow concerning it would be the $40 a month.
Per week.
Oh, $40, I'm sorry. That's right. $40 a week. Garnishment. Agreed on by the parties. And the order is to follow. Anything else on the record in docket 21-02347, Mr. Meineke?
Nothing further, Judge.
All right, I will await the order to follow. Do you have any questions of me, Mr. Robinson?
No, sir.
You're all set. Thank you for your appearance today.
Thank you.
Thank you, Mr. Meineke.
Thank you.
Let's leave the El Hood case till we'll see who shows up on the Mr. Dua's on the 2 o'clock. And then pretrial is for absolute resolutions, and I didn't see anything. But we're not too far from 2 o'clock right now. We do have an Arabic interpreter
For Mr. Alu.
for Mr. Al Hoot. who's not here.
Yeah, I mean, there's no one here for El Hoop.
Is there any interpreter here for El Hoop?
I did not see an interpreter out there.
Mr. Big is here for. Let's leave that and then we'll call that last, but
We have the defendant here for that one, if we want to call that one.
for,
The general civil, whatever, Mr. Baig is here for.
the absolute resolutions?
Yeah,
All right. And Ms. Minashki Simmons is here.
they're out in the hall.
Let's go and bring them in.
Okay.
Yeah. All right, Mr. Big, we have Mr. Simmons here, Minashki Simmons. So we'll go ahead and call that pretrial. Did you want to meet with with Minashki Simmons before that?
No, I just a scheduling order, maybe some discovery time to file.
So so we'll print out a pretrial
I'm
for,
working on
okay,
figuring out where I put it.
She's on her way in.
all right. It's a Miss Minashki Simmons. Okay. All right, Miss Simmons, you can have a seat up here. Are you Miss Minakshi Simmons? Okay. Let me pull that up because that's an e-file case. You can have a seat. And I have the opposing counsels on Zoom, but this is set for pretrial today. So I'm going to pull up the.
I have my family in the hallway. Are they on
The courtroom's open, so yes, you can bring them in.
Do
Yeah,
you mind if I just?
absolutely.
Sorry.
They can't sit up with you as a litigant, but they can sit back. I'm doing the thingamabob right now. I have to get to a lug nuts game. This is
Yeah, it'll be my first time actually.
really?
Really? I've never been to one.
I think they're fun.
Yeah.
It's
You know.
Thursday, you'll have fun.
Yeah.
$32.
Yeah. Yeah.
It is Thursday.
You have to call me out like that.
You're always giving me a hard time. I rarely get the chance to bother you.
Hold on. Latif. Oh, it's J. It's J Latif, I thought. Let's see.
That's correct, Your Honor.
Yeah. All right, so we're on the record in docket 25-00824. That's absolute resolutions versus Minakshi Simmons. Will the parties please introduce themselves for the record? Mr. Banks.
Good afternoon, Your Honor. Jay Baig, BAIG, bar number P36820, on behalf of plaintiff.
And ma'am, you are Minakshi Simmons, is that correct?
Yes, sir.
Right, thank you. This is the time set for a pretrial in the matter. And all a pretrial is at this stage is to set a game plan concerning dates and times. Okay, that's what we generally do, and we'll provide. So you have Mr. Baig's contact information. You can contact him if this is going to be a resolution of the case. But right now, we're just setting a time frame for any type of motions or things of that matter. All right, ma'am. All right.
I would have just
and
contact. I would just have her contact the attorney of record at Stanger and Stanger if she wants to discuss. It's Preston Nate, and his name and numbers on the notice of hearing.
All right, Preston Nate is the attorney of record Mr. Baig is just covering today. And so we'll do the pretrial. We'll set the dates out. We generally set it out about 90 days for discovery, for interrogatories or depositions, for the chance to get, but I'll walk you all through that. All right, ma'am? All right.
It's thinking about
And we're printing it right now as we speak.
Trying.
Or it's trying to print.
He's had 2 weeks off, so.
You haven't printed anything in 2 weeks? That's good news, by the way. All right. Thank you, Megan. All right, so we're on the record and pretrial statement of 25-00824. This is Mr. Begg is covering for Mr. Nate for absolute resolutions. And then Ms. Meenakshi Simmons is here for the defendant. How would we've described the issues concerning this pleading as a breach of contracts. You can be more specific if you'd like to. Mr. Begg, is there anything you'd like to add to those issues?
A breach of contract is sufficient.
All right. Ms. Simmons, is there anything you'd like to add? I'm not aware of the facts of the case, so I'm using it as kind of a summary label for the pretrial at this point.
Okay. Well, the situation is regarding a credit card I had.
It's a credit card account, so it is a breach of contract account.
Yeah.
All right. All right.
Yeah.
I'll put / credit card. All right. Do you anticipate, Mr. Begg, any more pleadings other than a motion for summary disposition?
No, just a motion for summary disposition.
All right. And we put that, so we've anticipated. Do you anticipate any more pleadings, Miss Simmons, concerning any of these events? I know that I know you haven't had you'll have the opportunity to speak with counsel concerning this matter. But do you plan on filing any pleadings?
I'm unsure.
All right.
What that.
I'll put pleadings. I'm gonna put the defendant is open at this time. I would expect, Mr. Begg, that we've anticipated there may be a motion for summary disposition, which is a legal motion to decide on the legality, whether you're in breach of contract or not. And then we also hold whether that you can respond to that. Okay, that's pending. Okay, that's generally filed before discovery closes, but that can be revisited. All right. I'm not consolidating this with any other case at this point. I'm saying that the admissions of fact are not applicable because we haven't gone through a discovery process. Exhibits are not applicable because we haven't gone through a discovery process. Discovery, I've set the cutoff date for discovery for July 27th, 2025. So motion for interrogatories or depositions, things of that nature. That's where you provide information or what information you have, or you get information. That date is set for July 27th. All right. So July, you might want to write that down. We'll also give you a copy of the order. Okay. Expert witnesses are not applicable since we haven't gone through discovery yet. Damages have been pleaded for in the complaint, but we don't have no future damages, so I'm not putting anything under. There's no joinder of claim. As Mr. Begg, have you paid for a jury trial in this matter?
No, we expect it's a bench trial.
So this is estimated to be a one-day bench trial in front of myself. If you wanted a jury trial, you'd have to pay extra money. All right, ma'am. All right. So that's been the possibility of settlement on negotiations are ongoing. And Mr. Begg, do you see a need for a case evaluation or mediation at this time?
No need for a case eval or mediation.
Right.
I think I was looking at her answer. She's stating that this is her husband's her ex-husband's debt pursuant to a divorce judgment. But I could tell you that unless absolute resolutions is part of that divorce judgment, it's not going to apply here.
So what I would recommend is that if you're relying on a document, a divorce document, you should get that to, or at least get a copy of that to the plaintiff so they can take a look at it and see if it's covered or not. Generally, it's got to be specific in regards to who's responsible for what. But I'll just leave it out there because I know nothing about the facts of the case. But I'll let you talk to Mr. Nate about those allegations. But I'm not going to set it then for evaluation or mediation since those do not seem to be appropriate measures at this time. Mr. Big, so we've got the cutoff date for July 27, 2025, and we've anticipated motion for summary disposition and response. The rest is pretty much left off the table until discovery is done. Do I have your permission to sign this via Zoom?
Yes, you do.
That would be absolute. Resolutions. All right, and then I'm going to provide, you can take a look at this, and there's a place for you to sign it, and my court officer will bring it to your attention here. All right, do you have any questions about the document you just signed, Ms. Simmons?
You said I'll receive a copy.
You're gonna get a copy today before you leave, all right? All right, so I'm gonna sign this at the request. You've signed it on behalf of yourself. I've signed it via Zoom. I will sign it as the sitting judge of the pretrial. And I will indicate that the pretrial has been complete. A copy will be sent to the attorney of record, and then you'll get a copy before you leave. We'll make a copy for you, and we'll sign and scan it. All right, ma'am? Do you have any questions concerning the pretrial, Mr. Begg?
No, Judge, thank you.
All right, you're all set, Mr. Begg. Do you have any questions of me, Ms. Simmons?
Not at the moment.
All right, you'll get a copy of this. If you're relying on the divorce settlement, you probably should let the attorney be aware, and then you probably should make sure you have a copy of that divorce settlement.
I do.
Okay, all right. All right, that's all for the record in that file. Ms. Simmons, thank you for your appearance, and my court officer will get you a copy.
Thank you.
You're welcome. We'll see you, Mr. Beck. Thank you for your appearance.
Thank you.
And then, sir, are you Terry Jimenez?
Yes, Your Honor.
All right.
I apologize for not being able to appear there. Been sick for the last couple days.
All right, and you're, so let me call your case in a second. That is a conditional dismissal, and Mr. Dua's on that case.
He was just in here.
Yes,
Judge,
Your Honor.
He said he just had a matter on Zoom. He had to take care of.
All right, so he'll be here in a few minutes, all right? So just stand by.
Yes, Your Honor. Your Honor, can I ask you a question?
You probably should wait until Mr. Dua gets here, all right, sir?
Yes, sir. Okay.
All right, thank you.
Your Honor, is there any way we can reschedule this since he's running so late?
No, he's here. He checked in and he's in another hearing. So we'll stand by. This is set for 2 o'clock, so 2:15. We'll go see if he's still in the other courtroom, but we know where he is. He did check in. He's in another courtroom.
Thank you, Your Honor.
All right, so Mr. Jimenez, we're ready to proceed on your case. We're on the record in 24011336. That is DS Huber Real Estate versus Terry Jimenez. Will the parties please introduce themselves to the record, Mr. Dua?
Thank you, Your Honor. Good afternoon. Sam Dua here on behalf of plaintiff.
And sir, you are Terry Jimenez, is that correct?
That is correct, the second.
All right, thank you. This is a time set for a, this initially stems, if I look at the notes of the case correctly, this was initially a conditional dismissal, and then some terms have not been met, or there've been some disagreement on terms. So Mr. Dua, I'll let you make a record, and then we'll go to Mr. Jimenez. How are we proceeding today?
Thank you. Your Honor, as you know, plaintiff submitted the request for the reopening of the case along with the default judgment and the order of eviction to issue. Plaintiff would surmise that Your Honor called this motion because many payments have in fact been made, and it has been just about a year since this has been filed. If you will recall, the initial consent order for conditional dismissal was on or around May 22nd, 2024, which said that the defendant would pay $425 per week beginning May 30th, 2024, every week, basically until the arrearage was caught up.
Correct. And I have that as part of written on the conditional dismissal, and then the defendant was to waive the 56 day.
Correct, because we knew that there was no way that it could be completed in 56 days.
Correct.
So as such, Your Honor, if the defendant had held true to what was supposed to be in the agreement and made all the payments, there would have been roughly $17,000 worth of payments made. Actually, it probably would have been a little less because he would have, the intention was for him to catch up by now. Unfortunately, instead, there was just a little over $10,000 in payments had been made. And although the defendant has been doing a great job of staying current, there's really been nothing that touched the arrearage. For example, when we came and we signed the conditional dismissal a year ago, there was $5,800 owed at that time. There's just about $5,000 owed at this time. So we're not getting anywhere. We're not making any progress towards the arrearage. Subsequently, Your Honor, you called this motion. The defendant contacted my office and requested a short adjournment to not appear in person because of some health issues. I told the defendant that unfortunately my client was not agreeing to that because of the arrearage. I told him that at the very least to show up by Zoom so that Your Honor could make a decision, because no real evidence needs to be presented here, and for the sake of his own health and everybody else's here, I thought maybe Zoom was a good option.
Okay.
But I did tell him it was your decision, of course.
All right, and so, and the conditional dismissal was signed, I have it here on May 22nd, 2024. We placed it on the record as we usually do. Mr. Jimenez, anything you want to indicate in regards to this is a resurrection of the case and a order of eviction, Mr. Jimenez?
Well, one of the things is I did not read this order all the way, and I didn't realize I could get an attorney appointed by the court, but I'm guessing that that's too far gone, right?
It's about a year, yeah, about a year ago is when we signed this, and you had 3 days from the date we signed it to say that something was vague or ambiguous concerning this matter. And so it's been about a year. We wouldn't pay for an attorney in any way concerning this matter. You signed a conditional dismissal on May 22nd, 2024, and then we placed it on the record.
Yes, sir. I've been working with DS Huber. I've been keeping in touch with them. I don't ignore them. I let them know for about the last year that myself and my mother had inherited the family farm and that we were going to get paid for it because it recently sold about 2 weeks ago. And so I'm going to be getting a large amount of money, and I let Mr. Dua know that if I could just be given 30 days, I can pay off the whole $5,000.
Right, but that was the conditional dismissal was signed a year ago. I don't know your standing on this, Mr. Dua,
If I
but
may, Your Honor.
we're over a year into it.
Understood. Your Honor, I did speak with the defendant today, in fact, and he gave me that information. I provided that information to my client. And unfortunately, because it has been a year, there have been alleged promises made in the past that didn't come through. If somehow the defendant could agree to do it in about 10 days, then plaintiff would likely be agreeable, but 30 days, they're not willing to.
Right, and what I would, and I would just set it, I can set it for a control date 10 days out to see if there's any payment. But other than that, 30 days is getting too long on a case that's a year old.
If it pleases the court, Your Honor, plaintiffs would, if Your Honor is inclined to rule in favor of plaintiff on this motion, plaintiff would agree to not enforce that order of eviction for a period of 10 days, although it had been signed by Your Honor.
All right.
As the control date that way. As an officer of the court, I could say that they would not enforce it for 10 days.
Right. So, Mr. Jimenez, what counsel has indicated is that they will give you, I will sign the order that once it's advanced to the court, I think it's already been filed.
It has, sir.
Yeah. And because you did sign a conditional dismissal, but they won't act on the signed order for 10 days to give you time. But that's all they're willing to give you is 10 days. 30 days after a year is too much time.
Understandable, Your Honor.
All right.
What is the minimum that I need to pay by 10 days, or do I need the full 5,000 in 10 days?
Let me give you a number. I'll give you a number, and that would be, so we'll have it on the record.
Thank you. Your Honor, I need just a second because that 10th day falls us into May, of course. So.
We'll give you a number. Let's calculate it, all right?
Yes, sir.
Okay. Okay.
And then costs of 163 for a total of 5,020, and that would be on the reinstatement.
Yes, so then I would just need.
So you'll need 1 day after.
7 plus 895 plus 25. So I would be $5,777 plus the 163 in costs, taking us to 5,940.
And that's even?
That's even. Yeah.
All right, so the number for the 10-day period, Mr. Jimenez, is $5,940.
And then what happens after that, sir?
They'll act on the order of eviction and the resurrection of the case.
If it's not paid by Tuesday, by the morning of Tuesday, May 6th, or if you have not moved out, then they could act on the order of eviction. If you pay it by Monday, May 5th, then your lease is just reinstated. You're right back where you were before.
All right, and if I can't come up with the full $5,940 by May 6th, how long will I have to be kicked out?
The order of eviction takes.
It would have already been signed.
Yeah,
so.
it'll already been signed. So that would be between yourself and the process server in order to make sure that your stuff's not on the corner.
All right.
Mr. Hernandez, if you know you can't get close by May 5th, plan on moving by May 5th, please.
Right. That I think that's a fair statement. If you see it coming and it's not going to be, you should be out by May 5th.
Yes, sir.
All right. All right. So I will sign the order for resurrection based on the conditional dismissal and the order for eviction that's been advanced to the court, and then that will not be acted on for 10 days. We have a full number of 5,940 as concerning the which will be the payment that would keep within the 10-day period, which will keep Mr. Jimenez and in possession of the property, so to speak. Other than that, do you have anything else on docket 2401-336, Mr. Dua?
Nothing further, Your Honor. Thank you.
Mr. Jimenez, do you have any questions of me?
Yes, since I moved in here, they put in a new maintenance squad. They hired, and they added another $25 a month to my rent for the last about 3 years. And every request that I've made, that the list that they gave me that they said they would do, they haven't done. I've even had a tree fall on my house, and they came over here and all they did was trim a tree at the top and didn't even take it away. And so I would like to ask that that extra $25 that I've been paying for 3 years come off of this 5940. I mean,
All
it's
right.
not gonna be a lot, but it'll help
With
me
that
out.
understanding that that 5940 is based on the original conditional dismissal.
Correct, yeah.
Yeah, it's not.
This, the 1 month for May 2025.
Yeah, so that you can act on that, but right now you've got bigger things to worry about than that, Mr. Jimenez.
I know, but every little bit counts. I mean, I'm just
right.
saying, because they were making me
All right.
pay for something that they wouldn't do, you know?
Right. The conditional dismissal was signed in last May. So do the best you can. You've got 10 days, and that I'll entertain any advancement. I'll sign it this afternoon. All right.
Thank you.
Thank you. You're all set, Mr. Jimenez. Thank you for your appearance today.
Thank you, sir.
And you're all set, Your Honor. You have
Flood me. $5,900 in 10 days.